not going to do it again, because I learned my mistake when I went down there to look at it and realized that we could build 2 dump fences or 3 dump fences and it's not working. So I am simply not going to waste the money to do something that I know will not work. So if somebody else wants to go and vote for the dump fence for the 2nd or 3rd time, go right ahead. But I was raised, when you make a mistake, admit it and then fix it. So I intend to fix it. And the fence that we're going to build, Senator Carper, Senator Colburn, Senator McCain and I, is a virtual, real and virtual fence that's actually going to work. And we'll have this debate further. I've got to yield the floor.
Under the previous order, the Senate will proceed to executive session to consider the following nominations, which the clerk will report.
Nominations of the Judiciary: Nitza I. Quinones, Alejandro of Pennsylvania, to be United States District Judge for the Eastern District of Pennsylvania. Jeffrey L. Schmehl of Pennsylvania, to be United States District Judge for the Eastern District of Pennsylvania.
Under the previous order, there will be 30 minutes of debate, equally divided in the usual form.
Mr. President,
Senator from Louisiana.
may I ask unanimous consent that we go into quorum call and the time be allocated equally as previously agreed to?
Without objection, the clerk will call the roll.
Thank you.
Mr. Alexander.
Immigration bill debate continuing in the Senate today. Lawmakers considering amendments to the bill this morning. A short time ago, they rejected an amendment offered by Senator Grassley of Iowa that would have barred a provisional legal status for immigrants until the Homeland Security Department could certify that the southern border of the U.S. was fully secure. The vote on that was 57 to 43. Again, that amendment rejected. Majority Leader Harry Reid, you may or may not have heard, say just a few moments ago that senators should expect to be in the chamber next weekend to finish work on the immigration bill before the July 4th holiday. Right now, time has been set aside for debate on 2 judicial nominations for judges from Pennsylvania. Votes on those are set to begin at noon. Majority Leader Reid indicating that those 2 votes would be the last votes for the week. As this quorum call continues on the Senate floor, we'll go to a discussion from this morning's Washington Journal on the Espionage Act, that is, what it is, what it encompasses, what its limitations are. And again, this is from today's Washington Journal.
Introduce you to Brian Fung. He is with the National Journal, and he is identified as a technology writer with the National Journal, but he's here to talk about the 1917 Espionage Act. What is it?
Well, so the 1917 Espionage Act was a measure that Woodrow Wilson proposed in order to try and prevent Americans from interfering with the war effort against Germany. And what wound up happening was that the Espionage Act gave the executive pretty broad authority both to indict people and also to monitor people's speech as well.
And what have people been prosecuted under the Espionage Act?
Yes, and critics of the Espionage Act have said that President Obama has actually used the Espionage Act more than any of his predecessors to go after leakers.
But in the past, what are some of the names that we might know from the Espionage Act?
Well, some of the most famous names, the Rosenbergs, who were spies for the Soviets, and you also have Jeffrey Sterling, who was a former CIA agent, who, in the most recent decade, was tried for giving information to a New York Times reporter named James Risen. And of course, now today you've got the Bradley Manning trial ongoing.
So what about a Jonathan Pollard or an Aldrich Ames? Were they tried under the Espionage Act? Do you know offhand?
Yes, they were. Ames in particular was investigated for giving information to the Russians. It was a major scandal back in the day.
But Bradley Manning? Is the Espionage Act being applied to him?
The government would like to, the government's argument is essentially that when Bradley Manning released a whole set of documents to WikiLeaks, among those was a video file.
This would be the Eastern District of Pennsylvania, the eastern side of our state, and obviously these appointments are critically important to justice and critically important to litigants who come before these courts, whether they're in civil or criminal matters. And these candidates go through an exhaustive review process. That's probably an understatement. The process through the nomination through the White House under any administration and then through the Senate, all kinds of reviews. So for them to get to this point, it's been a very long road, and we're grateful for that. And I know that one of the votes will be by voice, potentially, and one will be a roll call vote. But I wanted to talk about both candidates, and I did yesterday, but I'll just do it a little more briefly this morning. First of all, Judge Nitza Quinones Alejandro, who has served in the city of Philadelphia, the Common Pleas Court in the city of Philadelphia since 1991, what's known as the First Judicial District of Pennsylvania. That's the trial court in the city of Philadelphia. And you can just imagine in a big city like Philadelphia, all of the matters that a judge like Judge Quinones would deal with over the course of more than 2 decades now, dealing with civil and criminal cases, all kinds of difficult and complex matters that come before a judge, in essence performing the same functions as a county judge, in a sense, that she would on the federal district court. And so I think she's more than prepared to take on this assignment. This is also, I think in her case, a great American story. Judge Quinones was born in Puerto Rico, was educated there, came to the United States, and as I said, since 1991 has been on the Court of Common Pleas in Philadelphia. But prior to that, she was an arbitrator for more than a decade. She worked in the Department of Veterans Affairs. She worked in the Department of Health and Human Services. She was did a lot of work in the 1970s in community legal services in Philadelphia. So that speaks to a broad range of experience and expertise, dealing with litigants, representing clients, which is so important in our system, someone who takes on the responsibility to represent someone in court, to have their day in court, which is one of the foundational principles of our government. And then, of course, later serving as a judge, as I mentioned. So it's not only a resume and a life story that speaks to experience and knowledge and insight when it comes to dealing with complex matters that would come before the federal courts, but it is also in a very personal way a great American story. So I'm particularly grateful that her nomination is now coming to the Senate floor, and that we'll be able to have a vote on her nomination today. And I, on both of these nominations, have enjoyed working with Senator Toomey, both of us representing a big, diverse state, one Democrat, one Republican, working through this process to get federal judges appointed. And then also we'll be voting as well on a second judge in the Eastern District of Pennsylvania, Jeffrey Schmehl. I could say a lot of the same things about experience. Judge Schmehl is now the president judge of the Berks County Court of Common Pleas since 2007. So many years now in the trenches, so to speak, or in the, to use an expression from the Bible, laboring in the vineyards of dealing with cases and complex matters. Berks County, just by way of a geographic orientation, Berks County is north of Philadelphia, but on the eastern side of our state, and is a big county, a county that has a lot of matters that come before it that are particularly complex. He has served, as I mentioned, as a president judge of the Court of Common Pleas, but then prior to that was a judge on that same court from 1998 to 2007. So these are long periods of time in both instances, both Judge Schmehl and Judge Quinones, to serve on a court. And for those who know something about our judicial system and know a bit about the difference between an appellate court where you're dealing with appeals and legal arguments, as opposed to a trial court. The trial court is where the action is in terms of litigants. Trial judges have to be not just presiding over a trial, but have to deal with and rule on evidentiary matters. They have to deal with witnesses and lawyers and all of the complexities of a trial. And as we all know, when your case is on trial, it's the most important case in the world. So these judges have tremendous experience as trial judges, and we're so grateful that they're willing to put themselves forward, not just to be nominated and today confirmed as judges, as I'm sure they will be, but to put themselves forward for that kind of public service in a difficult environment, where the scrutiny and the review and the long road from nomination to confirmation can be very challenging. So again, I'll pay tribute to the work that Senator Toomey has done working with us. He's on the floor, and I want to thank him for that good work. And obviously the chairman of the Judiciary Committee, Senator Leahy, who's on the floor as well. We appreciate him working with our offices to move these nominations forward. And with that, I'll yield the floor.
And did the other senator from Pennsylvania wish to say something?
Mr. President, I would like to speak for several minutes, principally about the two judicial nominees.
I just want to make sure that I have time prior to the vote at noon. How long did the senator from Pennsylvania wish to speak?
I think I could wrap this up in less than 10 minutes.
Okay. Then, Mr. President, I would simply ask consent that there be 4 minutes for the senator from Vermont at the conclusion of the senator from Pennsylvania's comments.
Without objection.
And because it is from his state, I will step aside and let you go forward.
Great.
Senator from Pennsylvania.
Mr. President, thank you, Mr. President. I want to thank the chairman of the Judiciary Committee. And I do want to speak principally about the two nominees from Pennsylvania, both of whom I strongly support, and I'm delighted that they're going to get their vote today. But before I do that, I do want to put just a little bit of context on judicial nominations and confirmations as a general matter, because I think it's important that we understand this. In my own experience in the 2.5 years that I've been in the Senate, I know I've voted to confirm the vast majority of judicial nominees that President Obama has proposed for us. And in fact, since President Obama became president, the Senate has confirmed 193 district court nominees and blocked 2. That is a confirmation rate of about 99%. And the last Congress, the 112th Congress, confirmed more judges than any Congress in 20 years. So by any reasonable measure, we are confirming judges at a terrific rate. Republicans are cooperating and confirming the nominees of a Democratic president, and this as it should be when the nominees are competent as they have been. So President Obama is enjoying a rate of confirmation of judges that is far greater than the rate that President Bush, for instance, enjoyed, or most other previous recent presidents, which is part of the reason why I am concerned when I hear persistent rumors that the majority leader is considering invoking the nuclear option and breaking the rules so that he can change the rules as to how nominees get confirmed. I don't understand why there is a problem that would require this, and if he were to do this, this would be in direct contradiction to a commitment that he made to all of us very publicly that he would not do this. So I really hope that Senator Reid will keep his word and that he will not break the rules in order to change the rules. He stated very clearly in January of 2011 that, and I will quote Senator Reid saying, "I agree that the proper way to change Senate rules is through the procedures established in those rules, and I will oppose any effort in this Congress or the next to change the Senate rules other than through the regular order." And I would remind my colleagues that earlier this year, Republicans went along with the rule change that I had real reservations about. I personally couldn't support it, but most Republicans did change the rules, forfeiting some of the power that we have as a minority, granting the majority greater flexibility to go to a bill without assuring us that we'd be able to offer the amendments we would like. We granted that to the majority, in part because we got another explicit commitment that there would be no nuclear rule change if we made that agreement. Well, we did, at least as a party and as a body. And so, again, I certainly hope that Senator Reid will honor the promise that he made that was part of that understanding, where he said in January of this year, in an exchange with Senator McConnell, Senator Reid said any other resolutions relating to Senate procedure would be subject to a regular order process, including consideration by the Rules Committee. And I would add, that means a 67-vote majority in the Senate, because that's the way you change the rules in accordance with the rules. So having said that, I wanted to also make a brief mention of some terrific news that we got in Pennsylvania, and that is the opportunity for a little girl named Sarah Murnahan to have a lung transplant that she's been waiting on. I've spoken about this on the Senate floor. A federal judge in the Eastern District of Pennsylvania issued a temporary restraining order forbidding a rule that was keeping her off the list of potential donor transplanted lung recipient list. Fortunately, by virtue of that restraining order, she was able to go on the list and receive the lung. She had an emergency surgery just yesterday that seems to have gone very well, and we're all delighted for that and wishing for her speedy and full recovery. Having said that, as I indicated to the chairman, I wanted to come down principally and say how pleased I am that we're going to vote today, and I believe confirm both Judge Schmehl and Judge Nitza Quinones, who are two nominees for the Eastern District of Pennsylvania, both eminently qualified, terrific individuals who come highly recommended. I want to commend Senator Casey. He and I have worked together since I've gotten here. He's been terrific to work with. We've looked to identify some of the most capable and talented people. I just wanted to mention a couple of the things I know Senator Casey mentioned. Judge Schmehl, terrific guy, President Judge of the Berks County Court of Common Pleas. His candidacy was approved by voice vote in the Senate. He's a graduate of Dickinson College, has his J.D. from the University of Toledo Law School. He has served as a public defender. He has served in private practice. After serving for 9 years, he was elected to the Court of Common Pleas, where his colleagues made him the president judge. He is a very, very bright individual. He's got a keen intellect, a great judicial temperament. He's done a great job on the Berks County Court, and he will make a great federal judge. I hope my colleagues will support his candidacy. And Nitza Quinones, she's a native of Puerto Rico, graduate of the University of Puerto Rico School of Business Administration. And at the University of Puerto Rico, she got her J.D. She has really demonstrated a terrific commitment to the legal community and beyond that in Philadelphia. She's been very active mentoring young people, law students in particular, and as a great advocate of civic education for high school students. She has served on the Philadelphia Court of Common Pleas since 1991, presiding over a very large number of very diverse cases. She has extensive experience in the courtroom. She's demonstrated her ability, her commitment, her judicial temperament. As it happens, she'll be the first Latina judge on the Eastern District of Pennsylvania Court. I think it's terrific that we're able to vote today to confirm both of these judges. I look forward to continuing to work with Senator Casey to fill the remaining vacancies across Pennsylvania. I want to thank Chairman Leahy for his work in advancing these nominees and urge my colleagues to support their confirmation. And, Mr. President, I yield the floor.
Mr. President.
Senator from Vermont.
Mr. President, I appreciate the words of both senators from Pennsylvania. I would note there are currently 3 nominations pending for vacancies in the Eastern District of Pennsylvania. All 3 have the bipartisan support of the home state senators. All 3 were reported unanimously 3 months ago, but we talk about how things move here. Senate Republicans are permitting votes on only 2 of them. They're forcing Judge Luis Restrepo to continue to wait for a vote, even though he'd fill a seat that's been vacant for 4 years. I mention this because we talk about how things move with during this president's tenure as compared to that of his predecessor. At the end of President Bush's second term, I was chairman of the Judiciary Committee, and I expedited confirmations of 3 of his nominees to the same court. 3, not just allowing 2 to go through as my friends on the other side of the aisle are today, and not having to wait for months and months. Those 3 were confirmed by voice vote, and so you know how long it took. We had reported them out of the Judiciary Committee the day before. So they're confirmed along with 7 other of President Bush's district court nominees for a total of 10 on that day. We got them out of committee and voted them by voice vote. But now we have 7 judicial nominees on the calendar. Republicans are only allowing us to vote on 2 of them. So it really is insisting that President Obama played by a different set of rules than they had for President Bush. It's perfectly fine to expedite President Bush's 3 nominees to the Eastern District of Pennsylvania and confirm them all on the same day, along with 7 others. And Democratic-controlled Congress, and we moved them that way. But now with President Obama, they refuse to proceed with the 7 nominees awaiting final Senate action. They won't even proceed with the 3 judicial nominees needed in the Eastern District of Pennsylvania. So let's not talk about how presidents are treated, and I'm not sure what it is that's different about President Obama, but his nominees get delayed and delayed and delayed, unlike, and I use Pennsylvania as an example, where we vote out 3 unanimously of President Bush's nominees on one day, confirm them by voice vote the next day, along with 7 others. And here, they're refusing to proceed with the 7 nominees awaiting final Senate action. They won't even proceed with all 3 of the judicial nominees in the Eastern District of Pennsylvania. There are currently 7 vacancies on that court, 7. The Eastern District of Pennsylvania needs judges. Now, like the 2 nominees we're going to be permitted to vote on today, Judge Restrepo has the support as a Republican home state senator, as well as every single Republican member of the Judiciary Committee. So let's not make them wait. Before the recess, the minority leader asked during a floor debate when Gregory Phillips, the Wyoming nominee to the 10th Circuit, received a vote. Majority Leader Reid said, okay, let's vote him right now. They said, well, we're not ready. So I'll put my whole statement in the record, but the point is, we have these nominees. They can be voted on today. We ought to do it.
Mr. President,
Senator from Iowa.
I urge my colleagues to vote for the nominees that are before the Senate today. At this point in President Obama's term, when we get done with these 2 today, we will have approved 195 of the President's judicial appointments, and we have only disapproved 2. That's a 99+% voting record. It would help if the President would speed up getting his nominees up to the Senate. There are 81 vacancies now. The President has only submitted 29. That means that there's 52 vacancies that could be filled by the White House that the Senate would have an opportunity to work on as well. I also am going to take a couple minutes here to discuss something that I would have discussed in the Judiciary Committee meeting this morning, but because of our vote, I wasn't able to do it. First, I want to talk about the nominations hearing that we had earlier this week on B. Todd Jones. There's an open investigation in the Office of Special Counsel regarding very troubling allegations that Mr. Jones retaliated against whistleblowers in the U.S. Attorney's Office. He's now up for confirmation for the agency Alcohol, Tobacco, and Firearms. May I ask how many minutes before we vote? Senator, 3 minutes. 3. Last week, Carolyn Lerner, the special counsel who leads the office, wrote us a letter explaining the status of the matter. She wrote that the parties had agreed to participate in mediation. She also wrote, quote, if mediation's unsuccessful, the case would return to the Office of Special Counsel's Investigation Prosecution Division for further investigation. On Monday, she wrote us another letter confirming that the case was still open. Now we were told that the reason we had to move forward with a hearing was because an April letter from the Office of Special Counsel was made public. The justification for holding the hearing was that since that issue was made public, the nominee should have had an opportunity to respond at the hearing. But, of course, there was nothing confidential in the Office of Special Counsel's letter. I'm not about to hide this issue from the public. It is relevant to our inquiry as to the qualifications of the nominee. Moving forward under these circumstances is not consistent with past committee practices. And, of course, there are sensible reasons for that committee practice. First, none of us knows what the results of that investigation might be. How are we supposed to make an assessment of the matter while it is still open? Second, how are we supposed to ask the nominee about the results of the investigation when the investigation has not been completed? And third, how are we supposed to ask the nominee about an open investigation when the nominee will claim he can't talk about it for that exact reason. I would also note that an assistant U.S. attorney who filed the complaint against Mr. Jones gave his consent on Monday for the Office of Special Counsel to provide the complaint to the committee. And I must say that the allegations in the complaint are extremely troubling. So I began my questions by asking Mr. Jones about these allegations. Here's what he had to say, quote, "Because those complaints are confidential as a matter of law, I have not seen the substance of the complaints, nor can I comment on what they are. I have learned more from your statement today," meaning from this senator, "than what I knew before I came here this morning about the nature and substance of the complaints." In other words, Mr. Jones said he could not answer questions about the Office of Special Counsel investigation because it remains open. This is precisely why it is imprudent to move forward with a hearing in this way. At his hearing, I followed up with another question about Mr. Jones that had ever taken adverse personnel action. He responded, quote, "I'm not familiar with the OSC complaint. I'm at somewhat of a disadvantage with the facts. I can say that the Privacy Act considerations do fit into the picture," end of quote. As another follow-up, I asked him how we were supposed to ask about the complaint if he would not answer. Here's what Mr. Jones said, quote, "Well, quite frankly, Senator, I'm at a disadvantage with the facts. There is a process in place. I have not seen the OSC complaints." So we have a problem. And put the rest of my statement in the record. And also that statement that I gave in regard to the judges that we're voting on today.
Under the previous order, the question occurs on the Alejandro nomination. All those in favor say aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes do have it. The nomination is confirmed. Under the previous order, the question occurs on the Schmehl nomination.
Yeas and nays. Yeas and nays.
The yeas and nays are requested. Is there a sufficient second? There appears to be. The clerk will call the roll.
Mr. Alexander, Ms. Ayotte, Ms. Baldwin.
This is now the recorded vote.
Yes, sir. Oh, just a minute. Hey, Senator Brasso. Some for you. Sure. Yes, sir. Sorry.
Mr. Baucus.
That's it, right?
That's it. Mr. Begich. Sir. Oh. Mr. Bennett. Mr. Blumenthal. Mr. McConnell. Mr. Blunt. Mr. Bozeman. Mrs. Boxer. Mr. Brown. Mr. Burr. Ms. Cantwell. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Chambliss. Mr. Chiesa. Mr. Coates. Mr. Coburn. Mr. Cochran. Ms. Collins. Mr. Coons. Mr. Corker. Mr. Cornyn. Mr. Cowan. Mr. Crapo. Mr. Cruz. Mr. Donnelly. Mr. Durbin. Mr. Enzi. Mrs. Feinstein. Mrs. Fisher. Mr. Flake. Mr. Franken. Mrs. Mrs. Gillibrand, Mr. Graham, Mr. Grassley, Mrs. Hagan, Mr. Harkin, Mr. Hatch, Mr. Heinrich, Ms. Heitkamp, Mr. Heller, Ms. Hirono, Mr. Hoven, Mr. Inhofe, Mr. Isaacson, Mr. Johans, Mr. Johnson of Wisconsin, Mr. Johnson of South Dakota, Mr. Kane, Mr. King, Mr. Kirk, Ms. Klobuchar, Ms. Landrieu, Mr. Leahy, Mr. Lee, Mr. Levin, Mr. Manchin, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Ms. Mikulski, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Nelson, Mr. Paul, Mr. Portman, Mr. Pryor, Mr. Reed of Rhode Island, Mr. Reed of Nevada, Mr. Risch, Mr. Roberts, Mr. Rockefeller, Mr. Rubio, Mr. Sanders, Mr. Schatz, Mr. Schumer, Mr. Scott, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Stabenow, Mr. Tester, Mr. Thune, Mr. Toomey, Mr. Udall of Colorado, Mr. Udall of New Mexico, Mr. Vitter, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden. Senators voting in the affirmative: Baldwin, Barrasso, Burr, Cardin, Gillibrand, Graham, Grassley, Isaacson, Johnson of Wisconsin, Leahy, Lee, McConnell, Murray, Paul, Pryor, Schatz, Toomey, Vitter, and Warner. No senator voted in the negative. Mr. Whitehouse. Mr. Whitehouse, aye. Mr. Durbin. Mr. Durbin, aye. Mr. Coons. Mr. Coons, aye. Mr. Corker. Mr. Corker, aye.
Yes, sir.
Mr. Cowan. Mr. Cowan, aye. Ms. Warren. Ms. Warren, aye. Mr. Heinrich. Mr. Heinrich, aye. Mr. Reed. Mr. Reed of Rhode Island, aye. Ms. Landrieu. Ms. Landrieu, aye. Mrs. McCaskill. Mrs. McCaskill, aye.
John, how you doing? It looks like it's west of U.S.
Mr. Johnson. Mr. Johnson of South Dakota, aye. Mr. Chiesa. Aye. Mr. Chiesa, aye. Mr. Tester, aye. Mr. Sanders, aye. Mr. Moran. Mr. Moran, aye.
How was your 11 o'clock speech? Did you get Roberts yet?
Mr. Portman. Mr. Portman, aye.
Yes, you should. Yep.
Mr. Inhofe. Mr. Inhofe, aye. Mr. Donnelly. Mr. Donnelly, aye. Mrs. Fisher. Mrs. Fisher, aye. Mr. Cochran. Mr. Cochran, aye. Mr. Kane. Mr. Kane, aye. Mr. Roberts. Mr. Roberts, Aye. Mr. Levin. Mr. Levin. Aye. Mr. Kirk. Mr. Kirk. Aye. Mrs. Hagan. Mrs. Hagan. Aye. Mr. Nelson. Mr. Nelson. Aye. Mr. Cruz. Mr. Cruz. Aye. Yes, sir. Mr. Begich. Mr. Begich. Aye. Mr. Shelby. Mr. Shelby. Aye. Mr. Sessions. Aye. Mr. Baucus. Mr. Baucus. Aye. Ms. Ayotte. Ms. Ayotte. Aye.
I said she may become the next Earl of Pomeroy.
Mr. Johans. Mr. Johans. Aye. Ms. Heitkamp. Ms. Heitkamp. Aye. Mr. Wyden. Mr. Wyden. Aye. Ms. Collins. Ms. Collins. Aye. Mr. Manchin. Mr. Manchin. Aye. Mr. Coates. Mr. Coates. Aye. Ms. Stabenow. Ms. Stabenow. Aye. Mr. King. Mr. King. Aye. Mrs. Shaheen. Mrs. Shaheen. Aye. Mr. Blunt. Mr. Blunt. Aye. Ms. Mikulski. Ms. Mikulski. Aye. Mr. Franken.
Aye.
Mr. Franken. Aye. Mr. Brown. Mr. Brown. Aye. Mr. Bozeman. Mr. Bozeman. Aye. Mr. Risch. Mr. Risch. Aye. Mrs. Feinstein. Mrs. Feinstein. Aye. Mr. Alexander. Mr. Alexander. Aye. Mr. Crapo. Mr. Crapo. Aye. Mr. Rubio. Mr. Rubio. Aye. Ms. Cantwell. Ms. Cantwell, aye. Mr. Cornyn. Mr. Cornyn, aye. Mr. Coburn. Mr. Coburn, aye. Mr. Hatch. Mr. Hatch, aye. Mr. Chambliss. Mr. Chambliss, aye. Mr. Scott. Mr. Scott, aye. Mr. Udall. Mr. Udall of Colorado, aye. Mr. Thune. Mr. Thune, aye. Mrs. Boxer. Mrs. Boxer, aye. Ms. Hirano. Ms. Hirano, aye. Mr. Hoven. Mr. Hoven, aye. Mr. Carper. Mr. Carper, aye. Mr. Enzi. Mr. Enzi, aye. Mr. Heller. Mr. Heller, aye. Mr. Schumer. Mr. Schumer, aye. Ms. Klobuchar. Ms. Klobuchar, aye. Mr. Menendez. Mr. Menendez, aye. Mr. Flake. Mr. Flake, aye. Mr. Harkin. Mr. Harkin, aye. Mr. McCain. Mr. McCain, aye. Mr. Rockefeller. Mr. Rockefeller, aye. Ms. Murkowski. Ms. Murkowski, aye. Mr. Bennett. Mr. Bennett, aye. Mr. Udall. Mr. Udall of New Mexico, aye. Mr. Merkley. Mr. Merkley, aye. Mr. Casey. Mr. Casey, aye. Mr. Murphy. Mr. Murphy. Aye. Mr. Reed of Nevada. Aye.